So we've talked about civil and criminal cases, right? So I think we all kind of have an idea that certainly fraud can involve both criminal and civil cases, right? So if an employee has committed fraud against their employer, occupational fraud, they did fake invoices, well, that's a crime. It's the crime of fraud. So they might be charged with a crime and taken to criminal court, locked up, maybe sent to jail. But it's also a civil violation. In other words, that employer is out money, right? They could sue that employee to try and get that money back. So civil and criminal. So you've got this distinction. Criminal is an offense of a public nature. You know, fraud certainly is that. It's a crime against society. And civil law is a private right was violated. So if you were in a car wreck and it was somebody else's fault, they hit you, they just ran that stop sign and hit you, that's not a crime, that's an accident. And you could sue them and get a private remedy. All right, so we're going to talk first about civil litigation. So it's criminal litigation, and civil is completely different. So we're going to talk about that. So civil cases involve these 4 stages. Right, so in other words, especially in a fraud case, suing somebody who committed fraud against you, you stole my identity, you ran up my credit card bills, you declared bankruptcy, I'm going to sue you and try to recover personally, me, right? So I'm going to sue somebody. So here's the stages. There's investigation and pleadings, discovery, motion, practice, and negotiation, trial, and appeal. So they can overlap. Like I can be doing discovery, right? And then I put in a motion with the court, and the court turns it down. Well, I do some more discovery, I put in another motion. It's not like it's exactly linear. Although typically, if I'm going to sue somebody, I've done some investigation, and I sue them, and then they plead, and then we do discovery and motion and trial and appeal. But certainly during trial, there may be motions. During trial, there may be negotiation. May go back and do more discovery. Right? So it's not 100% linear. So let's talk about each of these. So the investigation and pleadings. So there's an initial investigation, and let's say I'm suing somebody who stole my identity, and I figured out who it was, and I sue them, I take them to court. I say, this person stole my identity. It caused me to lose my credit rating. I had to pay more in interest. I had to fix all this. It's cost me thousands of dollars, and I want them to pay me thousands of dollars, right? So I go to court, and I say, I'm suing this person for whatever reason. They hit me with their car. I had to repair my car. I broke my leg. I had to pay the doctor. I'm suing them, right? So you go to court, and you say, please get this person to give me $50,000. What you put a motion in. I'd like to sue this person, and my remedy is I'd like to give them $50,000. I'd like them to give me $50,000 or $100,000. You suggest a remedy, right? They've damaged me in this way, right? And so therefore, in order for this to be fixed, I need this much money, because that's pretty much all you can sue for is money. There is something called specific performance. That doesn't come up a lot, but typically the remedy is a certain amount of money. And then there's the answer, and they say, well, you know what, I didn't do that, and I'm not giving them anything. And they may even have a counterclaim. In fact, it's that other party who's at fault, and they've cost me money, so I expect them to pay me this plus my lawyer fees for having to show up for this, right? So that's the initial thing. You make some kind of a claim, a motion, and you say, here's what I want. And then they say, nope, usually. I mean, I suppose they could say, yep, here's your $50,000. But that's not typically what happens. They give an answer, and maybe even have a counterclaim. Next is discovery. So this discovery process is an actual process, and the attorneys get information about the other side's case. So, right, so I need to find out, well, I need information. If I'm going to sue them, I need information. And if you're being sued, you need to know what they know, right? Stuff like that. So you go through the court now, and the attorneys are going back and forth, and they're doing what's called production requests. You know, I need you to give me these records. Interrogatories, that's where you send people questions and they answer the questions. Requests for admission, I'd like you to admit that you did this, and we just won't even worry about getting evidence. You just say you did that, right? Subpoenas that makes them. A subpoena forces them to bring a document. That's the court tells them, right? So depositions. That's just where you sit and get asked questions. You're not at court yet, but the lawyers ask a bunch of questions to get information, and then motion and practice. And negotiation, going back and forth and going to the court with a motion and asking for something. Next, maybe settlement negotiations. Anybody can settle at any time. You know, if you sue somebody for $50,000 and they come back and say, well, how about 40? And you go, yeah, I'll take 40. That's done. Everything's right. That's fine. So that's what a settlement is. Most of the time, settlements are reached because it gets to be messy. Going to trial, you just don't ever know what's going to happen. So with a settlement negotiation, it's just you and the two parties involved, and you can figure out what you want to do and just agree. But sometimes it comes to a trial, and there's attorneys, there's a judge, there's the parties, and there's a jury. So you are going to have a lot more people get involved if you don't negotiate it out. But it's just like in a court. Maybe some of you have been to court and been a juror or something like that. So both sides present their evidence, and the jury and the judge come up with the remedy. Okay, yes, this happened. Here's how much you're going to get. No matter what you ask for, it could be a different amount. Then, if somebody doesn't like how it turned out, they can appeal. You can't always appeal. There has to be something that kind of wasn't right during the trial. Like the judge overrode this motion, but he shouldn't have. Or the lawyer introduced this information, but she shouldn't have. Right? So it's like you have a legit reason to ask to have it overturned. You can't just say, well, I don't like it. Right? There has to be some reason. So you can appeal. And on our next video, we'll talk about the criminal process.